Breaking news, the Republican effort to steal the North Carolina State Supreme Court election has officially failed. Jefferson Griffin, the candidate, has conceded. Welcome back to Democracy Docket. I'm Marc Elias.
And I'm Paige Moskowitz. Let's get started.
Paige, we have covered this story and all of the ins and the outs at Democracy Docket and on our YouTube channel from the beginning. This has been an effort by the Republican Party for month after month after month to steal an election in North Carolina. And today, it finally came to an end.
This morning, Jefferson Griffin's campaign released a statement saying that while they disagreed with the federal court's decision to reject his ballot challenges, he would obey the court ruling and he would not seek any further appeal. Marc, this brings this election contest to an end after literally 6 months. Jefferson Griffin has finally conceded. Democratic incumbent Justice Allison Riggs will be confirmed as the victor, as she should have been months ago, and will take her seat on North Carolina's highest court.
Yeah, and look, I think it's really important in this moment that we not give Jefferson Griffin a whole lot of credit. I am glad that he did not appeal this to the Fourth Circuit, but let's just be clear. This effort by the Republicans to steal an election that he lost in a recount, that he lost in a second partial recount, and which the plan by the Republicans, like their strategy over these months, have been to win by changing the rules of whose ballot counts after the election was held. And people need to hear this loud and clear. I am not saying people don't get to challenge the outcomes of close elections. There are lots of reasons why we have recounts. There are reasons why we have election contests. If Jefferson Griffin had come forward and said, look, I think that here are a handful of ballots that should have been counted that were erroneously rejected. Or for that matter, here are some ballots that had markings on them that I think are ambiguous and they shouldn't count that were. We'd be in a totally different place. But that is a process that is a normal process. What Jefferson Griffin and the Republican Party, backed by Washington, D.C. Republicans, have been doing for all of these months is advancing a legal theory that after the election was run, after voters had voted, they get to decide what the rules should be and how they should be changed, and then target those rules at heavily Democratic areas to disenfranchise. I think, Paige, at its height, they were seeking to disenfranchise over 65,000 voters who had done nothing wrong other than following the rules as they had been told.
Right. Griffin had claimed that about 60,000 North Carolinians who had voted in the state Supreme Court election had incomplete voter registrations. They didn't have all the necessary ID numbers that he claims needed to be a full registered voter. About 5,000 military and overseas voters didn't submit a proper copy of photo ID with their mail-in ballot. And a couple hundred voters whose residency in North Carolina was questioned. And Marc, like you said, it's not that Griffin challenged this wide category of ballots across the state. He targeted voters in Democratic counties. He said that, yes, while voters followed the instructions election officials had given them, they should still be rejected after the fact. And as we've talked about again and again, as state courts have said, as federal courts have said, you can't change the rules of an election after it's already been run.
Right. And, people need to realize that Jefferson Griffin didn't just come up with this idea. This wasn't like, his original idea. This goes all the way back to what Donald Trump tried to do in 2020. So if you remember, in 2020, in the aftermath of that election, Donald Trump and his allies filed more than 60 lawsuits. I know because my law firm and I, my legal team and I, were the ones who handled those cases for the DNC and for Joe Biden, and we defeated almost all of them. And the theory of the most aggressive of those lawsuits, all of which lost, was that Donald Trump could decide after the 2020 election was over that he just didn't like the way a state voted. And therefore, he could come up with a legal theory that their votes no longer count. And remember, he did this in Pennsylvania. His allies tried to do this in Georgia. He tried to do this in Wisconsin. He tried to do this in Nevada. This was like a strategy throughout the country. Ultimately, there was a case that they tried to file in the U.S. Supreme Court from Texas and a bunch of other states that Donald Trump supported to try to throw out the results of 4 entire states. Like, this was their strategy after 2020, and it is the strategy that failed. And ever since then, Donald Trump and the Republican Party and Republican candidates have been trying to get a toehold, to get a court to agree that they get to do this thing, which is wait till the election is resolved, then look at whose votes were for who, and then come up with sort of a retrofitted legal theory to disenfranchise the voters that they didn't like. And it's a strategy that we have not seen the end of. Like, we're going to see Republicans continue to do that. So for today, we should celebrate, but understand this is the legal theory that they are trying to crack the lock on. And it's one of the reasons why Democracy Docket has covered this North Carolina case so clearly. I mean, Paige, I don't know how many videos you and I have done. I know I've done several videos with Allison Riggs, who is the candidate who's been involved here. I've asked other guests who are, including Marita Jenkins recently in a video we did on redistricting about this. And the reason we've covered this so closely is because if they crack this lock, it will fundamentally change what it means to have free and fair elections. It'll fundamentally change democracy. So I'm going to make an ask of all of you, which is right now to make sure you are subscribed to Democracy Docket's YouTube channel. You can click the subscribe button, and you can also click the bell to make sure you are notified whenever there is a new video. And this is a way that we're able to keep you up to date on everything that is happening, not just through our newsletters, not just through our website, but also through these YouTube videos.
Marc, and I want to focus on Jefferson Griffin again, because it would be one thing if, any run-of-the-mill Republican candidate for a state legislative seat or something was contesting an election like this. But he is a judge, and he was running for a seat on North Carolina's highest court. He was running to be one of the judicial leaders in the state and promising that he'll uphold the rule of law, he'll make fair interpretations of the law, right? And then ran a 6-month-long campaign in the courts to change the outcome of his election because he lost. I think we need to focus on that a little more. It's not just that Jefferson Griffin is running this Republican playbook. It's that he was a judge trying to upend decades of legal precedent and fair election rules.
Yeah, and I think that's a really important point. I mean, if people go back and click on the links to the videos I did with Allison Riggs, who was also a judge or justice, and you can see how careful she was. You can see how judicial, to use a good phrase, and judicious she was in the way in which she talked about the election. You can go to Democracy Docket's website and look at the pleadings that were all filed in these cases. You could see how careful she and her legal team were to not exaggerate or not to make claims that seemed, injudicious. And like you said, you compare that to what Jefferson Griffin did here, which is he just became a Republican candidate, which is, look, I mean, these are partisan elections for state Supreme Court in North Carolina, which, I don't believe we should have elections for judges, but if we do, they shouldn't be partisan. But look, that's up to individual states. But as this evolved, as this litigation kept going, he looked more and more just like an agent of the Republican National Committee trying to steal an election, which is why, you and I started just calling it out for what it was, which was a Republican effort to steal an election. Too much of the legacy media tries to dance around this, and I even see it in some of the clips today. Like, this was nothing more than that. This was not a good faith dispute over whether the rules of the voting should be one way or another, because those disputes take place before election day, right? If you have a question about how the rules should be, you have those before election day. This was not a good faith dispute over small groups of ballots or individual ballots where you thought that votes should be counted, where people shouldn't be disenfranchised, or like I said, where there was ambiguity in a vote. This was a wholesale attempt to make a legal point, to make a principled point, to get a precedent that allows them to change the rules of voting after the election has taken place. And the fact that it was done by a sitting judge, as you point out, a court of appeals judge, by the way. So, this is an appellate judge, just shows where we have devolved in this country within the Republican Party. There's no fundamental difference, honestly, between Carrie Lake, who we used to describe as like an outlier, when she was running for Senate. Was it Senate or governor? I can't remember, but whatever she was running for in Arizona. We used to describe her as like, like setting the goalposts on one side. And then on the other side, we kind of had like these other mythical, sort of more traditional Republicans. They're all the same.
Marc, I want to zoom out a little bit because Jefferson Griffin started this election contest before Donald Trump was sworn in as for his second term in office. Since then, we have been seeing all of these lawsuits against Trump's executive orders. We've been seeing how various federal judges, liberals and conservative alike, have been issuing PIs and blocking the orders, saying that these are just blatantly unconstitutional. We also saw the state Supreme Court race in Wisconsin, where the Republican candidate there very quickly conceded. I'm going to ask you to speculate a little bit, but do you think that Jefferson Griffin maybe saw the bigger picture of how it had been playing out for Republican candidates and actions in court nationwide, and maybe that informed his decision to concede?
Look, as I said at the outset, I don't think Jefferson Griffin deserves a lot of credit for conceding. I think what he saw was the writing on the wall. I mean, let's just sort of zoom out, as you say. His best hope, and he understood this, was to have this resolved in the state courts, because the state Supreme Court of North Carolina is a partisan court. It's elected on a partisan basis. It also is a pretty partisan court, just like in the way in which the justices' temperament and decisions tends to be. And so he thought he had a chance to win there. And, coming out of the state court process, he still had two buckets of votes that he could still potentially gain enough margin and to flip the election results. It was not the biggest bucket. It was not the 60,000, but I think it was like a bucket of like 5,000-ish, and then a few hundred, as you say. And in a race where there's only, 700 and some odd votes deciding between the two candidates, that it was potentially enough. His gambit, I think, was that a federal court, because once the state court process was resolved, there were these federal constitutional claims. And my law firm brought some of those federal constitutional claims on behalf of individual voters and some nonprofit organizations. And there were these federal claims essentially saying these voters were going to be disenfranchised by having the rules changed afterwards. And his gambit was that that the federal courts would either stay out of it entirely or would be loath to get involved in this kind of state race with these cure processes and these disputes. And look, the case that was brought, the federal case that wound up being sort of the main vehicle that resolved this, was before a judge who was originally appointed by Donald Trump. So I always say that is not destiny, and this case is a good example of it. It was not destiny. The trial, that judge ruled against Jefferson Griffin and in favor of my law firm's clients and in favor of Allison Riggs and the Democratic Party of North Carolina, right? So, but I think his hope was that he'd get what he essentially needed out of the state courts, which he did. That he'd had what he thought was probably a favorable draw of a trial judge in federal court. And if he could win there, then, really the only thing that stood between him and victory was the Fourth Circuit. And there you're just dealing with sort of the roll of the dice of the panel you get. The Fourth Circuit leans more left than right. It has more members appointed by Democratic presidents than by Republican presidents, but you still have a diversity of judges. So I think that was probably his strategy. Once he lost as absolutely conclusively as he did before this trial judge, and I mean, you and I did a video when the trial judge opinion came out, and we can put a link to that. And you can tell you and I were somewhat like surprised, or by not just that Jefferson Griffin lost, but that this judge sort of took Jefferson Griffin to the woodshed. I mean, they lost on everything, and the judge's opinion read a lot like the indignant opinions that we saw after the 2020 election. So I think Jefferson Griffin read that opinion, both the substance of it, who the judge was, the tone of it, and just realized there was just no runway left. I mean, there isn't a chance that the Fourth Circuit was going to overturn this opinion by a conservative judge that was this outraged by what Jefferson Griffin was trying to do. And so if he wasn't going to win at this trial, at the trial court, which he didn't, and he wasn't going to win at the Fourth Circuit, which he wasn't, then, you know what? He seeks a cert petition in the U.S. Supreme Court. The Supreme Court is not going to take this case. I mean, the Supreme Court's got a lot of, you know, big cases that it's currently being flooded on its docket with. I just actually wrote a piece on Democracy Docket about 4 or 5 other petitions that conservatives have and Republicans have to try to get the Supreme Court to take election cases. And that was a piece that actually went out yesterday to Democracy Docket premium members. And if you want to sign up to either get Democracy Docket's free newsletters or its premium content, click on the link above. But, you know, there was no chance that this case was going to be one of the handful of cases. You know, the Supreme Court only decides 60, 70, 80 cases a term, and this case was not going to be one of them. So I think Jefferson Griffin bowed to the reality of the facts, not anything.
Now, while this saga over the North Carolina State Supreme Court is over, there are still other lawsuits ongoing in North Carolina concerning lawmakers' anti-democratic actions, power grabs, Republican ploys to take over elections in the state. Democracy Docket is continuing to track and cover those lawsuits as well. So make sure you're subscribed to stay informed.
Yeah. And like I said, please make sure you're also subscribed to this YouTube channel, because this is increasingly the way that Paige and I get you this breaking news, because we've learned, and you've told us, that many of you want to have sort of video content that is approachable, that is expert, and that is timely. So that's what we try to do. So make sure you are subscribed to this this YouTube channel, and that you're getting alerts when new content is posted. And of course, as always, make sure you sign up to Democracy Docket's free daily and weekly newsletters. The links, all of those are in the show notes. We will see you next time.